Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Group of Downing Fry, and today we're joined with our host Jim York and his guest Donald Ross Jr., President and CEO of Ross Title and Escrow.
Thank you, Morgan, for the introduction. Well, Don, thank you for coming on the show.
Thank you, Jim. Thanks for having me.
So the people that haven't seen you, let's just give them a little background on you and what's new with your company.
What's new, my son Christian has joined the firm. He's been practicing law for about 9 years up in Georgia and northern Florida. Actually, he's out working at the office right now. God bless him. So he's going to be assisting us in expanding the company and better serving our customers.
So it's going to be Ross and Ross, right?
It's going to be Ross and Ross, and we have about 8 people at the office. We do quite a few closings, as mentioned on prior shows. The ladies have been with me. My word, it's basically one family. Janet's been with me 38 years. Her daughter, Julie, 25. I've got an aunt who's been, if I don't get the dates right, I get in trouble, but it's 10 to 15, and then her daughter. And so it's a real nice family relationship where the continuity, I find, really helps avoid mistakes and miscommunications, and it's easier to train. You get the benefit of the training I put in when somebody stays with you a long time.
Yeah, and we've been using it for years, obviously.
Well, thank you.
People return calls, which is nice. But let's get to the subject today. So we're finishing up here 2021. We're going to be going into 22.
We are?
So I'd like to go back and tell our viewers what
happened in 2021.
Right, and what issues did we deal with, or agents did, or buyers and sellers?
We dealt with quite a few things in 2021. It's still COVID, but remarkably, you think of that COVID addendum that we've been working with. It really hasn't come up as an issue. It has not affected our ability to close or serve our customers. If people came off a plane early in the year, we'd meet them in the parking lot and sign things there. People wore masks, they had the temperature taken. So we all took extra precautions, extra cleaning measures within the office. But it did not slow down the closings. Ironically, closings really sped up to the point where people, and not just my company, but law firms and so forth, were working 7 days a week just handling the sheer volume of closings.
What issues did we incur, like multiple offers? Because we had record sales, and
we had multiple offers, but there were so many closings going on. A property would go out, and probably the most extreme example, we had one property with 20 offers. So you have the National Association of Realtors that has a manual of ethics and arbitration. And it does have, 3-4 pages on multiple offers. This is nationwide now, telling realtors this is how you do it. The key part, and there's addenda in both NABO and FABA that deal with this, but the key part is that the decision is the owner of the property, and you have to present all offers. And you want to have evidence in your file, if you're a realtor, that you sent in all 20 offers to the owner, because the owners in some cases would accept lower offers. They had a better feel for a lower offer.
One was cash, or one was
financing? One was cash, one was financing. When Christian, him and his wife, he bought a home on Marco, sight unseen, and the key point, ironically, was that he had 4 children. And the people selling were a retired couple of doctors from Cuba, and they liked the idea that a young family would be living in their home. So that was the deciding point over higher offers. So, people, the realtors would get upset if their higher offer isn't accepted. So it was very important for Jim York or whoever the realtor is
document
to
everything.
Show, save a copy of the email in your file that you sent in the offer, and you let the owner decide. They have their own financial criteria that they don't necessarily share with me or you or any other attorney or realtor. So multiple offers were massive, and they still are. And related to that, we had escalation clauses.
That's right.
And backup addendum. When NABOR came out with a backup addendum that I was getting questions on yesterday, on a Sunday, from one of Downing Fry's agents, how does it work? And depending upon how you fill that thing out, it gives the buyer a certain period. He has the right to step into the shoes of the first buyer with his contract if the first buyer's contract is terminated. And depending on how you fill it out, determines whether or not the second buyer can terminate the contract like right now without any notice, or they can't terminate it until 20 days from now. So I was advising the realtor yesterday, just leave that paragraph blank so that her buyer could terminate it at any time if they found something they liked better. So there's this the whole concept of backup offers, multiple offer addenda are all related to, in escalation clauses, they're really all part and parcel of the same phenomenon that we've seen, this huge upsurge of people coming to this part of the country to purchase, this widening of the demographic of people who are making purchases down here. My kids, 30-year-old on up are now buying down here, whereas, say, 3 years ago, probably most of the market were people, 50 and up. If I had to throw a dart at a board and guess.
Our age.
Our age. Well, not that if I were 50, but older folks, not the 30-year-olds who are still, working away, raising a young family. Now young families can move down here, and they are.
What's the next one you got on there?
The next one, the thing that came up quite a bit this year, because we've had change in the legislation on this, permits. And these are common problems with closings.
They are.
Permits are, whether they're open, whether there's non-permitted work, and surveys. Those come up all the time. Well, we were fortunate enough recently to get a new statute that deals with open permits that protects buyers for value of a property that has an open permit. So, permits were added to the NABOR contract in 2016.
Right.
And then people started searching for them. They never did before.
Right.
We discovered, my word, there's a bazillion open permits out there. It could be, shutters that weren't, the permit wasn't closed on them.
So an open permit for our viewers, just to tell them, is that, they had the contractor do some work, okay? And they opened up a permit to do the work, but they never had the final inspection, typically, from the county that can close out the permit.
They never did it. And contractors, my father was one, they're smart. They figured out that, hey, nobody's looking, so why go through this extra time and expense of having the county come out and do the final inspection? So, I routinely get open permits that are 20 years old, 15 years old, 10 years old, open permits for, say, repairing a roof, and then 5 years later you find out there's a permit that was pulled for a brand new roof, and that was closed. So is the earlier open permit even relevant anymore? Open permit on an air conditioner, that's no longer here because you got a new one.
Can that jeopardize a closing, having an open permit?
It's not a title defect. I've written a few articles on it, but the statute 553.79 precludes or forbids governmental agencies from issuing Jim York a permit. Say you want to do work on this house, and you apply for a permit to enclose your lanai, whatever work you wanted to do, and they found an open permit, say, on an air conditioner. The fact that you had an open permit, they could not stop issuing you a permit on enclosing the lanai.
Oh, okay.
Okay, and they couldn't fine you by having an open permit. So before they could go after the homeowner, and before they could say, we're not going to give you a permit for any additions or renovations until this thing is fixed, now there's a statute, because of all these thousands and thousands of open permits, now there's a statute that if you buy a place for value and money, the local government can't preclude you from applying for a permit and going forward. They can't penalize you, they can't fine you. They can go after the people, the owner who pulled the permit or the contractor who pulled the permit, but they can't go after the people who purchased the place. Now, if it was a gift, if your parents gave you this home and there was an open permit, a gift, that's not for value.
Right.
So the statute wouldn't help you there. So, you know, having that solved a lot of problems, but it also implies, or people are inferring anyways from that, that because something is open, they don't have to do anything. Now, I always caution my clients, just because you don't have to do it doesn't mean you shouldn't.
Can't try
Well,
to get it
if
done.
it's electrical work,
Right.
if it's plumbing work, you do want to have it checked out. You do want it to be safe. You don't want your kids, your grandkids, your friends getting electrocuted over an open permit that you didn't have to do anything, but you have noticed that, hey, you know, there's an open permit involving wiring. Have the wiring checked out. Make sure things are safe. So that was massive. Surveys come up all the time. I mean, surveys day in and day out, and I think it's been a while since we've talked about that, but I always urge realtors and sellers that if you have an old survey, produce it. Because 9 times out of 10, the old survey is absolutely fine, okay? In fact, I have one right now where the home was built, I'm trying to remember, I think it was 2008. It's a Lennar home, and the seller did not produce the original survey, which showed it was perfect, right setbacks, everything was fine. So the buyer had to go out and get their own survey. The buyer's survey showed a problem. They showed the setbacks by today's rules, not by when the house was built. So seller went digging for their old survey, because now we have a problem. Right. And with both surveys, you know, we had to send it into the county to verify which one controlled. The county, ironically, gives precedence to the more recent permit. The case law gives it to the older permit. So we're in the process right now of getting an administrative variance for the property. So all this could have been saved or avoided if they had produced the original Lennar survey.
And that could create a problem with the mortgage company too, I would think, right?
Yeah, they don't want homes sitting in setbacks.
Setbacks, exactly.
You know, they want the survey exception deleted on their mortgagee title insurance.
Before we go to the next one, let's just take a little break here.
Sure.
And we'll be back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Well, Don, let's continue this conversation.
Sure.
Okay, inspections.
Inspections, what we run into quite a bit. In fact, I was sitting in your driveway talking to somebody about an inspection issue. I've got a gentleman who's buying a $4.8 million home, and he's worried about the security of the framing around his windows. There's been a few water leaks.
Right.
So we had to have a long conversation on, you know, what you do with a situation like that, because they don't allow invasive testing. There's no way to really tell whether or not the 2x6s inside the cinder block are compromised or not, have they rotted or not over the years, until you pop the window out.
Right.
So, you know, inspections down here, what I run into quite a bit is with NABOR anyways, Naples Board of Realtors, a lot of folks just don't understand what's defective under the contract. They don't know. It's on page 6 of the contract. It has a very specific, like mold, only toxic and pathogenic, not allergenic. Mold is a defect.
Right.
You know, radon over 4.0 picocuries, which is a really tiny, small unit of measurement. You know, then, you know, what's cosmetic? You know, some of the things that are cosmetic, like limited roof life, would be an issue with the insurance company. But it's not a defect under the NABOR contract. You know, the insurance company might have an issue with the type of electrical panel, the Champion panels.
Right. Yep.
If they see one of those, they don't like it. But that's not a defect under the contract. So, you know, when you have a buyer pointing out on those 2 pages, here are the defects, and I've done this with my kids actually. I keep always thinking of my daughter when I think of this. And then also what's working condition and what's cosmetic. That, I think, would save a lot of headaches. You know.
Yeah, and what I usually do is, in our team, you know, my son and daughter, is we usually give them a contract prior to doing a contract, or even giving the seller a copy of the contract so they can read it over. It's not like rush. And then if any of our viewers would like to see one, I can email them a contract too, if they're looking for a house too. But it's you know, when you're doing something real quick, that's when you make mistakes. So we're trying to be proactive in giving them this information, explaining it to them in the, you know, early stages versus the later stages.
Well, that's a trick I learned from you, actually. You look at it psychologically. You know, somebody makes an offer to buy your home. There's a lot for the owner to absorb.
There is.
The amount of the price, you know, how much the deposit is there a financing contingency? Then they're seeing this contract that's different than they use in different, wherever they came from,
That's
whether
right.
it's Michigan or New York or Illinois. I mean, they use different forms. In some places, they're not forms, they're just handcrafted by the attorneys. So if you can eliminate some of that psychological stress up front, like you do, give them the contract so it's familiar when they get it. Just the numbers might be different than they thought.
That's right, exactly.
You know, so,
hopefully higher in this market.
and they have a chance to ask questions before they have that time crunch of responding to the offer. I mean, we have that provision in the inspection clause that the cost to repair something cannot exceed fair market value. So if you have a 15-year-old air conditioner, you don't get a new one.
Yeah.
That's line 315.
That's right.
And you know, if you just give it to them, you know, it's just one line.
Right.
But everybody skips over it. A lot of agents miss it. So, you know, what's defective? What's working condition? I underline where is it? You know, what's cosmetic, and I point out the limited roof life, and then I point out that one line. Now that doesn't mean if I'm representing a buyer, we don't ask for the new air conditioner. We sure as heck do.
Yeah.
You never know, you might get one.
That's right.
I mean, my daughter, when she bought her house, she got a new. They split the cost of a new air conditioner when it died. So. You know, that I get questions on day in and day out.
And that leads us into the next question, incomplete contracts, right?
Yeah,
So.
and in preparation for the show, I went around to my closers and asked, I'm doing a show with Jim, this is our topic, what do you folks see as common issues day in and day out? And it's just incomplete contracts. Oftentimes the wrong address is on the contract. Oftentimes they leave out, you know, parking spaces. They might have 2 parking spaces, only supposed to be 1 parking space, or boat slips.
Right.
And you know, a lot of these condos or HOAs, you can internally transfer. If you have, say, 2 parking spaces, you can transfer one of yours to your neighbor.
That's
and
true.
Each association has a different way of doing it.
Yeah, that's true. Yeah.
It's not necessarily recorded at the courthouse. It might just be with the association. So you know that we get errors in the address, we get errors, we get missing information on the loan. Paragraph 1 in the NABOR contract gives the purchase price $100.
Yep.
$20 deposit. How much is the mortgage? They don't say.
That's right.
They leave that out. They leave out the interest rate, which to me it just concerns me because I want people to read the contract. I don't want them to be surprised. I'm not picking on people because they make
No, and
errors.
that's, I tell people I don't like surprises. I don't deal good with that. So that's why I'm being proactive and explaining all this beforehand, because I'd rather give you we should be looking for now versus later. And,
Well, I think a good rule of thumb would be just fill out every blank.
Yeah, right.
And that will force people, I hope, to read what blank they're filling in, and then that'll prompt a few questions. So you'll have fewer indignant clients when you get to the closing table. The paragraph 6 in the NABOR contract that deals with special assessments, I find a lot of confusion over. People look at when the payments are being billed by the association, not when they were identified as to the lien or the property being liened in the amount, which is a criteria in paragraph 6. So we, probably once every couple of weeks, we'll have somebody say, wait a minute, those payments are due next year.
Right.
Well, sorry, I mean, according to paragraph 6, it's when they passed it, you know who was placing the lien, the association, the amount, say $10,000, and the property, yours. So there's specific rules on how that's, who pays for what. And in a nutshell, the seller pays for everything before the effective date. That's when the contract was fully executed. The buyer pays for things after the signatures on the contract, but before the closing date, up to 1% of the purchase price. So if it's $1 million property, it's 1%, 10,000. So they're responsible for the 10,000. Anything over that, the seller is responsible for. But if the seller says, no, I'm not going to pay that extra 2,000, whatever it is, then the buyer has an opportunity to cancel it. And then everything after closing is the buyer's problem. But I have a lot of conversations over that. That probably is a big issue day in and day out.
Well, Don, I appreciate you coming on the show, and I wish you a Merry Christmas. I wish everyone else a Merry Christmas and Happy New Year, and we'll see you in January. Thank you.
See you next year.
Yep.